On the set of Black Swan, two interns signed up to learn filmmaking. Instead, they spent their days filing paperwork, running the photocopier, and picking up lunch orders for a crew that never taught them one real technique. Years later, a federal court reviewed that exact task list and ruled the work would have required paid employees, not implied. Ruled. Here's a stranger case. A journalism graduate, already done with school, re-enrolls in a graduate program she has no intention of finishing. She pays tuition, real money, out of pocket, for the sole purpose of staying legally enrolled as a student. Why? Because the internship she wants only takes students, and being a student is the only way to make unpaid legal work possible. A third case. A college reporter wakes before dawn, drives 90 minutes each way at 6 in the morning, and pays tuition for a class that exists mostly on paper, because enrollment in that class is the ticket that unlocks an unpaid newsroom slot. The commute is real, the tuition is real, the paycheck at the end of it is zero. Now the number that explains why any of this is worth doing. Survey data from the National Association of Colleges and Employers puts it in stark terms. Paid interns convert into full job offers roughly 72% of the time. Unpaid interns convert at roughly 44%. Same title on the resume. Same word, internship, on both sides. Wildly different payout. Look back at the three people you just met. The film intern doing admin work. The graduate re-enrolling just to stay eligible. The reporter driving 90 minutes for a class that only exists to unlock a badge. None of that is ambition. None of it is laziness. Every one of those stories comes down to the same single variable: who can afford to work for free. So let's say the thesis plainly, once, and move on. This was never a debate about hard work. It was never about who wants it more. It is a filtering mechanism, a system that decides who gets in before anyone even looks at talent. And the toll it charges at the gate isn't effort, it's your bank balance. Give it a name, because you're going to hear it again and again. Call it the sorting machine. Not a training program, not a stepping stone. A machine engineered to filter who enters a competitive industry, with money as the sorting variable instead of skill. Every unpaid internship you'll hear about tonight runs through that same machine. Here's where the machine takes us over the next 4 levels. Level 1. How a legal loophole let companies relabel free labor as training. Level 2. How courts tried, and mostly failed, to shut that loophole down. Level 3. Exactly who this system favors, and who it was built to keep out. Level 4. What other countries did instead of leaving the loophole open. Level 1. This is the part nobody teaches you in school. How paying someone nothing for real work became legal in America in the first place. Not through some grand debate about fairness, through a quiet redefinition. Somewhere along the way, free labor got relabeled as training. And once it wore that label, the law simply stopped calling it wage theft. Start with the baseline, because it matters. The Fair Labor Standards Act, passed in 1938, set the default rule for American work. If you perform labor for someone else's benefit, you get paid at least minimum wage. No carve-out was written in for interns. That word doesn't even appear in the statute. So any exception the industry uses today had to come from somewhere else. That somewhere else was one Supreme Court case. Walling versus Portland Terminal Company, decided in 1947. Railroad trainees sued for wages during a short unpaid course. The court sided with the railroad, ruling that when a trainee benefits more than the employer does, no employment relationship exists and no wage is owed. One narrow railroad case. It ended up rewriting the rules for an entire economy. Here's the exploit, plain and simple. The Portland Terminal ruling never mentioned the word intern. It didn't have to. All a company needs to to do is call the arrangement training on paper, structure it to resemble education instead of labor, and the wage requirement quietly disappears. Change the label, keep the same photocopier, the same filing cabinet, the same lunch run, and the paycheck vanishes with the word. Then the machine gets a stamp of legitimacy. In 1969, the White House formalizes its own internship program, unpaid, of course. Suddenly, the most powerful office in the country runs the exact same model as that film set. Real work, zero pay, dressed up as opportunity. Once the White House does it, unpaid stops being a red flag and starts being a resume line everyone wants. From there, it spreads fast. Through the 1980s and 90s, media companies, entertainment studios, and political offices all adopt the same default. If you want in, you start unpaid. These become known as the glamour fields. Journalism, film, fashion, politics, industries everyone dreams of entering, which means everyone will tolerate the entry fee. Demand made the loophole permanent. Then 2008 hit, and the machine found its accelerant. Companies gutted payroll, Condé Nast, ad agencies, entertainment houses, laying off paid assistants by the dozen. The work didn't disappear. It got quietly reassigned to unpaid interns. Same desks, same deadlines, same client calls, zero salary. A recession didn't slow the sorting machine down. It handed the machine a permanent staffing solution. Look at the postings data and the pattern is stark. Internship listings didn't shrink during the downturn. They multiplied. Between 2008 and 2012, unpaid internship postings surged as paid entry-level roles kept vanishing. The machine's throughput didn't dip in a recession. It scaled. Fewer paid jobs, more unpaid gates, and thousands more people lining up to pay the toll. Level 2, the fight back. For decades, the machine ran unchallenged. No lawsuits, no rulings, just a quiet legal fiction everyone accepted. That changed when a handful of interns stopped accepting the arrangement and started reading the actual statute. What followed was a decade of courtroom battles that would reveal exactly how thin the legal justification for unpaid labor really was. 2011, two production interns, Eric Glatt and Alexander Footman, filed suit against Fox Searchlight Pictures. Both had worked unpaid on the 2010 film Black Swan, doing accounting, filing paperwork, running errands, the same tasks a paid employee would do. Their claim was simple. Under federal law, they weren't trainees. They were staff who never got a paycheck. The case would become the defining test of the entire system. 2013, a federal district court ruled in the intern's favor. The judge applied the Department of Labor's strict six-factor test, the one requiring that unpaid work benefit the intern more than the employer, mirror vocational training, and displace no paid staff. Fox Searchlight failed nearly every factor. For once, the machine lost in open court, and the ruling sent a shockwave through every industry running on free labor. The win didn't last. In 2015, the Second Circuit Court of Appeals reversed the decision. Instead of the strict six-factor test, the appellate judges invented something looser, a seven-factor primary beneficiary standard, asking only who benefited more overall, employer or intern, with no single factor decisive. The case got sent back down to be retried under the new, employer-friendlier rules the court had just written. By 2016, the case that started it all quietly settled. Total payout, roughly $2,500 per intern. Compare that to months of unpaid, full-time labor in New York City, production work, 12-hour days, real deliverables. $2,500 was the price the legal system assigned to a violation strong enough to reach the Second Circuit. That's the ceiling risk for breaking the rule. January 2018, the Department of Labor made it official. The agency formally adopted the Second Circuit's primary beneficiary test as national policy, replacing its own stricter six-factor standard everywhere in the country. A weaker test born from one appellate ruling became the baseline for every unpaid internship in America. The exception the courts carved out for one company had just become the rule for all of them. Meanwhile, Condé Nast was fighting its own lawsuit. Interns at the New Yorker and W magazine revealed pay stubs showing roughly $1 an hour for full work weeks. Rather than raise wages to the federal minimum, Condé Nast chose a different exit in 2013. It cancelled its entire internship program company-wide. Faced with a choice between paying interns fairly or eliminating the position, the machine chose elimination. NBC Universal took a different route. In 2013, the company agreed to pay $6.4 million, settling answering claims from thousands of unpaid interns going back to 2007. That's roughly 6 years of free labor across every division: news, entertainment, cable, bought back for a lump sum small enough to barely register on a media conglomerate's balance sheet. The math still favored the machine. Then came Wang versus Hearst Corporation, another magazine empire lawsuit over unpaid interns. This time the court refused to draw a clean line. No blanket rule, the judges said. It depends on the specific facts of each internship, case by case. That sounds neutral. In practice, it meant no company could be told in advance it was breaking the law. Ambiguity became the best shield an employer could ask for. Look at the pattern across every one of these cases. Black Swan, $2,500 ahead. NBC Universal, a fraction of 6 years' wages. Condé Nast, canceled the program rather than pay minimum wage at all. Every settlement is a rounding error next to the value of years of free labor extracted beforehand. That's not a deterrent, that's a fine, and a company can budget for a fine. Level 3, who actually gets filtered out. Every internship listing shows you the job title, the company name, the maybe stipend. None of them show you the real cost of entry, the line item that decides, before a single interview happens, who even gets to compete for these jobs in the first place. That number doesn't live in the posting, it lives in your bank account. Run the actual math. 3 unpaid months in New York or Los Angeles, rent alone averages $3,000 to $5,000 before a single meal, subway fare, or rideshare gets counted. Add food and transit, and you're clearing $8,000 to $10,000 with zero income coming in, and often wages lost from the job you'd otherwise be working instead. That's the entry fee nobody prints on the listing. Federal minimum wage has sat frozen at $7.25 an hour since 2009. 16 years, zero movement. While rent in the cities where these industries actually operate, New York, Los Angeles, DC, has roughly doubled. Even internships labeled paid often clear minimum wage on paper and still leave you short every month. The math was broken before the internship even started. There's a term for this: opportunity hoarding. Nobody's stealing anyone's advantage outright. No scandal, no headline. It's just quietly reserved, position by position, for whoever can already absorb the cost of taking it. The kid whose parents can cover 3 unpaid months in Manhattan gets the credential. The kid who can't, doesn't. Same talent, same resume, different starting bank balance decides the outcome. 2013. Wang versus Phoenix Satellite Television. A federal court rules that an unpaid intern isn't legally an employee, which means she has no standing to sue under the same law that would have protected a paid coworker. She'd alleged sexual harassment on the job. The court's answer wasn't "you're wrong," it was "you don't count." The same loophole that let companies skip her paycheck also stripped her of legal protection. The fallout moved fast. Within months, New York City amends its human rights law specifically to cover unpaid interns. California follows, then Oregon, Illinois, Washington, D.C. 4 jurisdictions patch a hole in their own legal code. Not proactively, not because someone flagged the risk, but because one woman lost a harassment case first. The protection existed, it just needed a real victim to prove it was missing. If tracing how systems like this actually get built and quietly defended once someone notices is useful to you, that's what this channel does. Not hot takes, not outrage for its own sake, just a mechanism laid out clean. Subscribe if that's the kind of thing you want in your feed. I do this regularly. That's the deal. Capitol Hill ran on unpaid interns for decades. Congress, the body that writes the labor law everyone else has to follow, staffed its own offices with students working for free, sometimes 60 hours a week, which means the only people shaping those laws early in their careers were the ones whose families could bankroll a summer in one of the most expensive cities in the country. 2016, the Pay Our Interns campaign launches, aimed directly at Congress's own hypocrisy. The pitch is simple. You cannot write labor protections for the rest of America while running an internship program that would violate those same protections in the private sector. It's not a subtle argument. It's just one nobody in leadership had bothered to make out loud before. 2018, Congress appropriates funding to pay house interns. 2 years of direct pressure, and the institution that literally writes the country's labor law finally admits it can't justify breaking it inside its own building. Notice what that timeline says. It took a dedicated campaign, sustained for 2 years, to get one workplace to follow the standard it sets for every other workplace in America. So that's the American version. But unpaid internships aren't some universal law of how economies train young workers. They're a specific choice, one the US made and other countries didn't. Look at what France and Germany did instead, and the loophole starts looking less like an inevitability and more like a policy decision nobody in Washington wanted to make. France closed it in 2010. Any internship longer than 2 months legally requires a gratification, a mandatory stipend, currently around €600 a month minimum, paid directly by the company. No exceptions carved out for prestige, no it's an honor to be here. The law simply removed the option to run someone for 8 weeks or more without paying them anything. Germany drew the line differently. Any internship over 3 months falls under the national minimum wage law. Full stop. Unless it's strictly required by a degree program, like a mandatory clinical placement. That's the entire exception. One narrow carve-out, tightly defined, tied to an actual academic requirement. Not this could be educational. Not you'll learn a lot. A specific verifiable degree mandate, or you pay minimum wage. The US never did either of those things at the federal level. No mandatory stipend, no minimum wage default with a narrow academic exception, just Portland Terminal's 79-year-old test, still standing, patched only where a state or a city decided to bother. If you're interning in a state without its own fix, none of those protections apply to you. The loophole is still fully operational in most of the country. Now, to be fair, not every unpaid arrangement is the sorting machine in disguise. Student teaching, medical clinical rotations. These run unpaid too, but they come wrapped in structure most corporate internships never touch. Mandatory supervision, credit hours tied to accreditation, a licensed professional signing off on every stage. The output isn't cheap labor for a company. It's a required, monitored step toward a license. So here's the honest distinction, and it's not the one most people reach for. Those programs are unpaid because of tight regulatory oversight, not because someone found a gap in the law and quietly climbed through it. The difference was never about the paycheck, it's about supervision. One version is built and monitored to teach you. The other just needed a legal argument that let it skip paying you. Here's the counter risk, and it's real. Mandate pay across the board, and some outlets cut the program entirely. Condé Nast didn't raise wages after their 2013 settlement. They shut the internship desk down. Full stop. Small non-profits with 4-figure budgets can't absorb a state minimum wage times 40 hours times 12 interns. The door doesn't get fairer, it just gets fewer doors. This isn't a morality play, it's a design problem. Outlaw the entry fee and the sorting machine doesn't disappear. It just recalibrates. Fewer unpaid seats means fewer total seats, and the ones left get more competitive, not more accessible. You didn't remove the filter, you just tightened the mesh, and now even more applicants are fighting for what's left. Go back to Black Swan vs Fox Searchlight one more time, because the court said it plainly. The unpaid work, they wrote, gave Fox Searchlight an immediate advantage. 6 words. That's not a judge's opinion, that's a factual finding about who profits and who doesn't. The company got labor. The intern got a line on a resume and rent still due. The sorting machine doesn't care about any single ruling. Black Swan, Wang vs Phoenix, Condé Nast settlement, France's mandatory stipend law. Each one is a wrench thrown into the gears, not a shutdown switch. The machine slows, it grinds, it occasionally throws a spark. 80 years after Portland Terminal, it's still running, just with more litigation bolted onto the side. No pep talk here. The machine is still running right now, today, across most of this country, in newsrooms and studios and non-profits from coast to coast. In 80 years, the only variable that's actually changed isn't whether the door has a fee, it's who's finally willing to say out loud who can afford to pay it and who can't. Here's the number I'll leave you with. uncomfortable as it is. Most interns in this country still couldn't tell you with a straight face which side of that machine they're actually standing on, the ones getting sorted in or the ones just paying the toll to be seen. No conclusion, just the machine still running.